Good evening. It is Tuesday, January 22nd. This is a meeting of the Nahant Conservation Commission. The Nahant Conservation Commission is holding this public meeting at the Nahant Town Hall on the proposed wetlands bylaw regulations. The purpose of this meeting is to solicit public comment on the proposed wetlands bylaw regulations. Hopefully everybody has a copy of the regulations, but if you don't, there are some copies up here. You're welcome to grab one. And there's also the map that was originally issued as part of the town meeting. Nope. There aren't enough. There may have to be some sharing. Yeah. Do you want?
We saved some trees. There may need to be some sharing. Sorry about that.
I only made 10 copies. Sorry.
There may need to be some sharing. Apologize.
Hold on.
Well, so now we're blind. Well, you've got one. That's good.
I'll let you have mine.
This is mine. This is super dry.
Awesome. Hi, everybody. So as the Conservation Committee, you saw we saved some paper, so please feel free to share the copies of the draft regulations. Also, I want to note that the nice map makes very nice wall art when we're done, so feel free to put it up in your kitchen. Just a quick opening statement and just letting everybody know. So there's a couple things. One, I really truly believe we have a special... Yeah, certainly. I can bring it closer. Well, perfect. Let's do introductions first. That sounds good. I'll start with introducing myself. My name's Ben Harvey, and I've actually been in Nahant now for about 1.5 years. I'm a newbie.
My name is Kristen Kent, and I am the chair.
Ellen Steves.
Tom Fabulari.
Meredith Thibault.
And Henry Hall.
And then Amy Questle, Town Council.
Great. So, we live in a special place in Nahant, and I want to say about this meeting, even though we have folks that are on different sides of this opinion, I think that we all can say that we're all trying to do what's best for our town. The one thing that we won't do tonight, so tonight is really intended for questions about the regulations, comments on the regulations, and us trying to get the regulations correct. It will not be a relitigation of the town vote, and so the town vote has happened. Based on this, I do want to set some baseline understandings about the regulations. A couple of things. One, the regulations, we didn't kind of just make them up out of thin air. And so the regulations have all been taken from other towns that have used it. So if we look at 78 coastal communities in Massachusetts, 68 of those have these type of regulations. And so there wasn't a need for us to go and write these brand new. There were 68 model regulations out there for us to use from. We pulled a lot from Rockports, from Chatham, from Orleans and Dennis. And so again, this idea that we're an outlier, actually 68 of 78 of the coastal communities have these type of regulations, and we were able to rely on those for this purpose. The only other thing I'll say about tonight is we do have a lot of people here, and we have a limited amount of time. So we're going to limit comments to 5 minutes. It's not to say that we can't extend for special purposes, but the intent being to make sure that everybody who wants to speak has a chance to share their opinion. Okay? And with that, I'll pass it back over to Kristen.
So I guess probably the best way is if you would like to make comments, you can cue at the mic, and we'll just start going through and hearing what everybody has to say.
Nice movie.
So, is this working now?
It is.
Oh, good. Okay. So thank you. It was good to see this the regulations, and I'm glad that we have an opportunity to comment. I went through them, and I understand that they need to be adopted by you, approved by the selectmen in order to take effect. And it was my observation that, despite the fact that they were taken from other towns, that there still remained a number of questions and clarifications that I think need to be made. So I'm just going to go through them. I'll try to keep it to 5 minutes. So the first comment I have is that under definitions and exemptions in section 15, it says repair, maintenance, improvement of existing structures, blah, 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 are exempt. In the bylaw itself, it says exemptions, it lists exemptions and says these shall apply only to properties that are 100 feet, I think it said, outside of the protected zone. So I would like to hear whether these exemptions apply only to those properties outside the zone, or if under section 15, those exemptions now apply to any structure. Then I'm also a little concerned that there is inconsistency in jurisdiction, and I hope that that can be clarified. The town has a stormwater runoff or stormwater bylaw that's actually pretty clearly written, makes it clear that the authority to implement that law rests with the planning board. A lot of the regulations here, enforcement rests with the Conservation Commission. I think that there's some inconsistency in terms of which activities are governed by which board. For example, one of the listed activities in the Concom rules and regulations has to do with runoff displacement or diversion of floodwater, for example, is clearly a stormwater-related thing. So I would like to know whether the Conservation Commission and the Planning Board, I'd like to hear how you two bodies have met and agreed on which activities would be covered by which. And that's particularly relevant because under the new bylaw, the Concom bylaw, denials can be appealed only in Superior Court, which obviously entails costs and so on and so forth. And under the stormwater bylaw, it's the Department of Environmental Protection. And under the state, it's also the Department of Environmental Protection. So I would like some clarification as to the competing jurisdictions and the competing processes. I'd like to see those really spelled out. It would be very helpful to hear how the Planning Board and the Concom have resolved these issues, maybe point by point, comparing the two laws. I'm not going to talk about a tree warden because that doesn't seem to be that important, but the rules say that they are not intended to duplicate what's already existing in the State Wetlands Protection Act, and I would find it really helpful to know specifically what activities are already covered under the Wetlands Act and what additional activities are to be reviewed by the Concom, and those that are not already covered. Again, as with asking for a point-by-point comparison of the Planning Board's authority and the Concom's, I would really like to hear, and I would think the Selectmen would, a comparison of what is covered in the wetlands state law and what is covered by yours. A listing would be very helpful. I've mentioned already the DEP versus the Superior Court. It seems to me that citizens will be very concerned with that. Also, there's a Chapter 1 seawall license process that's regulated by the state, and it has very specific requirements for seawall maintenance and repair. I'd like to know how those are going to be resolved. Are you going to work together? Are there additional requirements? Might they at times be in conflict? If they are in conflict, how is that going to be resolved? One of the things that I was sort of mystified by is this hearing about a delineation. We spent a lot of time going over the map, the orange, the pink, the yellow, and yet a public hearing with public notice and fees and this and that are required to determine whether your property is subject to this bylaw. And in a simple case, I'm just wondering what the rationale is if the areas that are delineated in the map are definitive. I'm also concerned, I noticed in the stormwater bylaw, scientists that are authorized to do plans are defined. In these rules and regulations, it says we need a wetland scientist or engineer. Engineers are clearly defined by the state. Wetland scientist is not. And I'd like to know what are the criteria for authorizing a wetland scientist to submit plans and certify them and so on and so forth. It would be really useful to have some guidance. The language of these regulations is quite impenetrable, I think people will find, and a little guidance about the forms that need to be filled, who fills them out, where the information can be obtained would be extremely helpful. Another concern that I have, I'm sorry if I'm running over 5, is that there seems to be some inconsistency in that the regulations specifically say you can't do anything that would prevent the homeowner from protecting against sea level rise, like migration of wetlands and things like that. But the purpose of a lot of people's activities is precisely to protect against adverse effects of the sea level rise, and I would think that protecting our property would be pretty important. Another point that I think is quite important is timing. So there's specifications about how long before a meeting that you need to submit an application and how long after a meeting, 21 days, a verification will be made or a certification will be made. But there's nothing about if the docket of the Concom becomes full, is there some time limit after an application by when a hearing, in fact, will be held? The nature of that hearing, who needs to attend, how is it, where is it held, that has not been specified. So I'd like that to be clarified in the final rules and regulations. I think one of the things that struck me about this is that there was no discussion or consideration of the administrative burden. I know when the federal government implements new rules, they have to do an assessment of the staffing needs, the tasks that are included, that new tasks that would be required, and I think that such an assessment really should be done before these regulations are adopted.
We're at about
I'm not going to get into
7.5
aesthetic values.
minutes, so if we can. We're at 7.5 minutes, so if you,
Okay.
I'll give you another minute.
So
and then
that's
you
fine
can always
because I
come
think
back up.
more people will talk about aesthetic values and the completely meaningless definition, so I don't need to. But I've listed, and I will share this with the selectmen, these items which I think really require resolution and clarification before they can reasonably rule, because there are just questions that are left, and I would like to see that resolution shared publicly with the town as well as with the selectmen. Thank you.
Great. It would be helpful, I recognize you were going to share that with the selectmen, if you would not mind sharing it with us in writing so we can actually respond. Perfect, so we can respond to you point by point. The other thing I will say, just in response, is we can look at a number of regulations both on our books and across the state and the country, and the specificity of regulation that's being asked. That would be a bar that would put this regulation far exceeding any other regulation written. So I think that we can try to provide as much clarification as possible. The storm drainage between the planning board and the Concom, there's been a Zen overlap for a while now. Even before this regulation, there's been some overlap. And so we'll do our best to clarify that, to show where overlap and how, if we can, we will deal with that. But just recognizing in the writing of regulations.
I would point out this is an opportunity to address that concern.
That's right. And we will try to do our best to do that.
So before we move on, why don't we just tick off a couple that are easy ones to address? The stormwater. The stormwater bylaw we enacted because it's a requirement of the NIPD's MS4 permit. It was written so broadly so that basically most properties in Nahant aren't affected by it, and that was on purpose, probably, to avoid administrative burden for the town. A lot of towns did that. They didn't make it more stringent. So as a result, you have to disturb an acre or more of land or move 100 cubic yards of soil. Very few, if any, properties in Nahant are capable of meeting that threshold. One of the Furthermore, in the regs, stormwater regs, it specifically says that if you have an order of conditions or decision from the Conservation Commission, that supersedes the stormwater permit, the stormwater bylaw. So by virtue of that, it automatically defers to the Conservation Commission. So I don't see that there's any conflict there, and that's something that Amy and I have talked about, that we don't see that there's a conflict between the stormwater bylaw and these regulations. With regard to Chapter 91, many seawalls in Nahant don't have Chapter 91 permits. It's not unusual. A lot of people have just done things over the years. The regulations for seawalls are very specific in the Wetlands Protection Act, so that's something that I don't envision us messing with. It's very specific, and DEP in many cases, even since the storm last year, has stopped us from issuing permits until additional information was submitted because they're so specific. So this is not, the intention of this is not to be more stringent than DEP standards. The map that you guys have, that is a map based on FEMA's floodplain mapping and the DEP wetlands mapping. It is not a definitive map. It is a representation of potential areas that would be subject to jurisdiction. If you have wetlands on your property, or you have stormwater floodplain on your property, that's something that needs to be decided by a surveyor or a wetland scientist in the field. It is not decided based on that map. That is just informational. With regard to the forms that need to be filed, it's exactly the same as what's required under the Wetlands Protection Act now. This is a great opportunity for us to update the town website, which hasn't been done in a million years, and that information can be put up there so it's available. Oftentimes, the Conservation Commission goes and helps people fill out the forms so they don't have to hire anybody. We've done that a ton this fall, trying to help people get their seawall and damage from the storm taken care of. With regarding to the meeting requirements, when you need to submit information is dictated by the need to submit a legal ad to the newspaper. So a legal ad needs to be in the newspaper 5 days before. You need to post the meeting 2 days, 48 hours before. We meet as needed to make sure that people get their work done as fast as they can. We don't hold people up. However, we do have 21 days to meet, should we choose to do so. As far as the that also, yeah.
But it is not, I would love to see that explicit.
We certainly could.
Days after an application to schedule the meeting.
I think the intent of the regulations was to, as far as the filing, was to track the Wetlands Protection Act, so that we're not having different filing requirements for the Wetlands Protection Act and the bylaws. That would make it confusing. So the intent is for it to track the Wetlands Protection Act, and in that it's 21 days. The administrative burden. Since the enactment of the bylaw, we have had one person file just under the bylaw, and it was to take down a garage. Everyone else has already had to file under the Wetlands Protection Act, so this was no additional burden for them. We've had one filing since August. That's it. So this hasn't changed our burden thus far. This fall, we met every other week to accommodate people so that they could get their work done. You know, the commission is really good about doing what it needs to do to help people in town, because we specifically know we have no staff. So this is something that, you know, we go out of our way to do for people. I think that's it, unless you wanted to.
Do the exemptions apply to everyone or only outside the buffer?
That's something I need to look at.
Yeah,
I need to
so
reread. I can't off the top of my head.
The citizens of Nahant would really like.
Well, don't worry. We will get clarification on that. And so part of this is there's no way we're going to be able to answer everything with clarification. We have attorneys and things for that. And so we will certainly, idea is to get those questions, answer what we can and get that information out there, but not to give incorrect answers. So on those that we can't give an answer on, we'll make sure we get that answer and we'll get it out to everybody. Perfect, please.
Brendan Baronic Olmsted, 2 Summer Street. Starting off, out of the 68 communities that have regulations, how many of them include aesthetic value in the regulations? That's one of my first questions. On the definitions, the definition of aesthetic value is basically a subjective definition, and I also wanted you, if you could define what natural is, because Nahant used to have sheep herders, and most of our forests have been clear cut and regrowth, so we don't really have a natural environment, what we consider a pristine environment anymore. So I also wonder, how does the natural environment impact our ability to deal with invasive species? Because a lot of our species have been here for 100 years or more, so they're now natural. Let's see. Next point. On section 5, point A, at the very end of the definition, it includes interest in aesthetic value, interest of aesthetic and recreation. The aesthetic part, still I'm wondering where the metrics are to determine the aesthetic value. And I'm also wondering a broader question of what does aesthetic value have to deal with flood control? Engineering design is not necessarily based upon aesthetics, it's based upon good engineering. That same point also deals with part B, the presumption, the same part about aesthetics. Under part C, the performance standards, there's no aesthetic metrics. There's a whole variety of metrics that are clearly defined and can be objectively determined, but there's no mention of aesthetics. As well, and now in section 7 of the order of condition, that order of conditions have to be filed with the Essex Registry of Deeds. Is that a new requirement, or has that always existed?
Always existed.
Okay. Let's see what else. Under section 14, under monitoring permitted work, it says projects in close proximity, less than 50 feet of a wetland. So does that mean all homeowners along the coast are going to need a babysitter? Because anyone who owns coastal property is within 50 feet of a coastal wetland.
Do you want to go through your list and we'll do
Oh,
it?
yep,
after, or
yep.
you wanna do this?
Okay, under section 15, part B, the consideration of aesthetic value does not apply to the exemption activities listed above, and comma, to the construction or extensions of a single-family home or a building of a new structure separate from a single-family home on a residential lot. What is a single-family home? Is that one family in one house? Is that someone who rents out an apartment? Someone who has a family house and they rent out another apartment? Is that someone who's got 2 floors and their mother lives on the first floor and they're on the second? Because that seems to would impact a lot of people in town, that these exemptions for doing basic repair work would not apply to them. And I think those are all the questions I've got.
Okay, so let's quickly, just the easy ones. So with regard to aesthetic values, at the town meeting, that was clearly a concern, and we absolutely heard that, and that's why we tried to address it in the bylaw. The Massachusetts Association of Conservation Commission's model bylaw includes the term aesthetic, and that's why it was carried into ours. Since it was a concern, we tried to address it, so we borrowed from Carver's regulations and basically exempt all single-family homes and properties. That way, we're scoping here. We're not eliminating, because we can't go back and change something in the bylaw without town meeting, so this was our opportunity to scope that term. With regard to invasive species, there is a state invasive species list. It is not, newer. It's Phragmites, Japanese knotweed, those types of species that are aggressive and invasive. It's not, ones that are brought here 100 years ago and clearly weren't native. There's a difference between native species and invasive species, or non-native species. Recording orders of conditions is required by the Wetlands Protection Act, and it has been required since the inception of the Act. So with regard to monitoring, it says the commission may require. That is something that's common. I've worked on many projects that were monitored by a wetland scientist or an engineer, because oftentimes things aren't done the way they're permitted. So if there's a particularly environmental sensitive location, or if there's a property that in the past has been known to not follow the rules, it gives the commission the opportunity to require an environmental monitor.
My name's Michael Manning, live at 12 Fenno Way. I got 3 sentences into the act to the part where it said, wetland resource areas established under Article 17 of the Town of Nahant General Government Bylaws, Wetlands Protection Bylaw. The only problem is that's an incorrect citation. Article 17 of the Nahant bylaws is the stormwater discharge bylaw, and on the town clerk's website, where it lists the existing town bylaws, it doesn't have the one that passed at the special town meeting yet, so it doesn't have a number. But that at a minimum needs to be corrected. Again, getting to a sentence which follows from that, it says, it's not the intention of these regulations to duplicate review that is already taking place under the Commission's jurisdiction pursuant to General Laws, Chapter 131, Section 40, the State Wetlands Protection Act. In truth, I was expecting a set of regulations that would be Nahant specific and not covered by either the State Wetlands Protection Act or the rules and regulations of the state, which tend to cover almost all of the items that are in these rules and regulations. And so I was really looking for the difference. It would be really helpful not having to compare these 18 pages with the more than 150 pages in the State Act and the state regulations to point out those sections that are really Nahant specific. The only ones I could find was that when you sent in an application on the state form, you had to add to the state form and the Town of Nahant Wetlands Protection Bylaw in pencil and pen as a correction to the state form, and you had to attach the fee form for the Town of Nahant, the list of abutters, and the return of service, either from the post office or a constable, that shows. Other than that, it was hard for me to detect something that was really Nahant specific or over and above what's required in the state law, except the new 100-foot buffer zone that was added in the bylaw. With that, I'll move on. The definition that was just talked about, aesthetic values, I would echo the comments of Mr. Olmsted, who spoke before me, and say the only word that I could think of that categorized that definition was it was indefinite. I had to read it about 7 times before the English words that are in the right order, punctuated properly, etc., came close to coming to a definition, because it isn't a definition. It doesn't really say what aesthetic values are. If you look at the next 3 or 4 definitions in the list of definitions you had, they're all concrete, they're specific, they're easy to understand. So if someone is supposed to, from this, understand what you mean by aesthetic values, other than some hand waving that you would get if you expected it's not aesthetically pleasing, that would be what it is. So while I applaud you for answering a criticism which I've leveled at the special town meeting and other meetings, that aesthetic was undefined in the state law, the state rules and regulations, our local bylaw, or any other environmental regulation that I know of. I think, well, we've got the title in there for a definition. What's in there for a definition doesn't serve the purpose. It really needs to be improved. In the section under land subject to coastal storm flooding, on page 9, it mentions interest of aesthetics or recreation. And I wasn't sure that, because it isn't capitalized, it isn't followed by the word values, but the aesthetics at that point aren't aesthetic values. So again, I'm wondering, what are the interests of aesthetics and recreation, since they're in there in kind of an undefined term. In the following pages, you use LSCSF as an acronym, which it took me a while to figure out and go back to the title of that section, land subject to coastal storm flowage, to understand that that's what that meant, so that perhaps you could put a parenthetical in there so that people aren't surprised when it appears. Number 7, you have a section entitled Pre-Acquisition Violation, which, when I took civics and history, American history, a long time ago, we learned what ex post facto laws were. And this is a striking example of what one is. You may be liable now for something you did before, when something you did before wasn't necessarily a problem. So I think there needs to be, at a minimum, something put in there that says, after the enactment of the local bylaw, or after the enactment of these rules and regulations, otherwise you've got an open-ended penalty and violation for people who have probably had something for 40 or 50 years that they didn't know they were in non-compliance for. Since the buzzer has rung, I'm going to wait, and I'll get back in line, and somewhere else I'll come up and I'll bring up a couple of.
Coming back up to the mic is completely acceptable, and we appreciate it.
Yes, hi, thanks for holding this meeting. Andrew Carl, homeowner, 28 Fox Hill Road. And my concern is more general. I don't want to get into specifics, but really for me, that's just what I want to do. My concern is for basically any repairs or additions on my existing property, and under altering section F, driving of piles, erection or repair of building or structures of any kind. That says to me, if I want to put a roof on my house, I have to go through all this. Okay, so where is this explained in more depth, this section? Okay, and if I were to, and under this alteration, it says, as defined in the Wetlands Protection Bylaw, includes without limitation, which means, you know, to me, it says if you want to do any of this, you can't. So I need some clarification on that. I don't see any clarification in this. And, you know, the second thing I want to know is, prior to this regulation being implemented, if I were to do, say, put an addition on a property, say 2 years ago, and I want to apply to put an addition on my property now, what are the big differences? And I think that would be a general thing for everyone to understand a little better, because this is very confusing to me. So that's really about it for me. I just wanted some general clarification. Yeah.
So I think the jurisdiction of the Conservation Commission kicks in when you change the ground, the land. So if you're putting a roof on, or you're putting new siding on, or you're putting a door or window, the Conservation Commission does not have jurisdiction because you're not changing the land. So if you're in floodplain,
Yep.
Are you in the floodplain?
Yes.
So already under the Wetlands Protection Act, if you wanted to do an addition, you would have had to come to us. That continues to be the case. The filing process is the same because we don't have different forms, so you'd file the same information with us. So for people who are already under the Wetlands Protection Act jurisdiction, this does not demonstrably change what you need to do. The only thing it really changes is for people who are in the buffer zone. So now they would have to come to us, and they didn't used to have to do that. So if you're doing run-of-the-mill, stuff to the structure, the existing structure, you don't need to come to the Conservation Commission. If you're going to change the footprint of your structure or add additional impervious surfaces, then you have to come to the Conservation Commission.
Can you explain the buffer zone? I'm not clear on what that is exactly.
So I don't know what color it is on the map. I can't remember. Yellow, thank you. So are you already in the floodplain?
Yes.
So this doesn't necessarily pertain to you, but there was the wetlands bylaw added a 100-foot buffer zone to the FEMA floodplain maps. So those are people that either maybe in the future are going to be in floodplain, or they, in some cases, not all cases, because, you know, slowly FEMA changes the maps over and over and they grab more people in, but not everybody. So, so those are people that didn't used to have to file, but will have to file with the Conservation Commission now, or get an opinion as to whether or not they need to file.
So let me get this clear. So people who are in this buffer zone have to pertain to this more stringently than someone that wasn't in the buffer zone?
They have to do it now, and they didn't used to have to do that.
Oh,
Yeah, there's no increased stringent, it's just more people.
that's the only difference, okay. Okay, that's it, thank you.
And I just wanted to address 2 points that have come up multiple times. One on the aesthetics. I hear there is no definition that we will be able to write that will make aesthetics objective. That's just, you know, that'll make it objective. There's no way we can do it. And so the question is then, is aesthetics in or is aesthetics out? And the model rules and rules throughout, you know, have used that. And what I can say is, from the Conservation Committee, and I think we're somewhat proud of this, we haven't heard many people come up and, excuse my language, say, you screwed me, right? We brought our stuff to the Conservation Committee and you ruined it. You didn't pass it. You weren't fair. It's just, we really do try our best to make sure that we protect our homeowners, that we help them get done what needs to get done, and we do it in a timely way and get that through. And so I think that recognizing that this regulation brings some additional homeowners into that purview, I think that you can feel comfortable that the approach of the Conservation Committee will not change from its historic approach, which has been one that has been helpful and has approved projects.
Good evening. Jody Grawl, 65A Bass Point Road. I've been a lawyer for 40 years, and I was a commissioner on the Nahant Conservation Commission in the early 90s. I have a working knowledge of the Wetlands Protection Act. I'm certainly not an expert. What I'd like to say is I do not envy your job as unpaid citizen volunteers writing these regulations. Environmental regulations are like insurance policies or IRS regulations. You have inclusions unless they're accepted. You have exceptions unless they're included. Definitions of terms seem to differ in different contexts. Words and phrases are not interchangeable. You used the word floodplain earlier in your discussion. The floodplain actually is not defined in the regulations, that I don't believe it's in the bylaw. The floodplain, for purposes of flood insurance, is not the same as a wetland resource area. A wetland may not actually have surface water on it if the existing vegetation consists of plants recognized as growing in wetlands. In other words, it's a very difficult and confusing, especially if you're doing it for the first and only time. I don't want to speak for or against the proposed regulations. I just want to make sure that the regulations are crafted in a manner that achieves not only the intended results, but also avoids unintended consequences. I do want to ask some questions about what are the goals you wish to achieve and whether these proposed regulations will achieve them. Lastly, I hope the final draft of the regulations does not subject the average single-family homeowner in Nahant to an expensive, time-consuming, stressful process prior to beginning construction, which is itself very unpleasant. The bylaw covers, quote, wetlands as defined by the bylaw and land within 100 feet of the wetlands. So the formula is wetlands plus 100 feet equals wetland resource area, which is covered by the bylaw. In the postcard I received, there was a map of Nahant with some salmon-colored areas, primarily around the shoreline perimeter, with yellow areas supplementing the interior portion of the salmon areas. I think you've already covered that, and I do not believe that map is even part of the bylaw. As you said, I think it's just for information purposes. However, I think a map is a great idea for the town. Just as the town has a zoning map delineating the various zoning districts, in a definitive map of the town's wetland resource areas would be very helpful to property owners, realtors, banks and other lending institutions, insurers, appraisers, board of assessors, home buyers, building inspectors, and the Nahant Conservation Commissioners. Such a map should be incorporated into the regulations. Both the bylaw and proposed regulations refer to, quote, surge of record or storm of record with regard to land subject to coastal storm flowage. This defines the wetland resource area. Do such records exist? Were any records made to document the extent of coastal storm flows during the blizzard of '78? The no-name storm in October 1991, or Winter Storm Riley in March of 2018. Were the areas flooded by these storms plus 100 feet define the wetlands resource area? Should there be a pamphlet with step-by-step procedures and illustrations of wetland resource areas to assist a project proponent who simply cannot afford to hire professional help to apply for a determination or a permit? Do you want the regulations to be one size fits all? Should a single-family homeowner on a 5,000 square foot lot who wants to add a deck to its house be required to comply with the same provisions and meet the same standards as a major project costing 6 figures or more, involving thousands of square feet of resource area? Should there be categories of projects based upon size and/or cost? Just the cost of a site plan could be in the thousands of dollars if the regulations are strictly followed, to include delineation of all wetland resource areas, property boundaries, existing topographic features, elevations of the project site, 1 or 5 foot contours, soil samples, delineation data sheets, vegetation plot sites being staked or flagged in the field, and a narrative report. Should there be a waiver provision which allows the Conservation Commission to waive one or more regulatory provisions based upon its own knowledge and experience that the proposed activity in the wetlands resource will have no or insignificant impact? Should there be a provision encouraging...
I'm going to butt in just for a quick second. We're coming up on 7.5, and so if you're close to the end...
I'll
that's
finish
perfect.
this
Feel
up.
free to
Okay.
finish or come back. That's perfect. Go
Should
ahead.
there be a provision encouraging or requiring a site visit by the Conservation Commission? Looking at a two-dimensional plan in a hearing room should be supplemented by a physical exam of the proposed activity.
I know a lot of commissioners make that part of their review. They'll go and look at the property. I think it would be helpful for not present company, but later commissioners to actually put that in as a requirement. The bylaw contains time standards. Should these standards be carried over and repeated in the regulations? Should there be an expedited procedure for minor projects and for a request for determination? Some things are very simple, very easy. You talked about not increasing the footprint or things that don't affect. Very quick, very easy. It's something that somebody say, no, this doesn't apply to you. No even request for determination is required. You're okay, go ahead and get your building permit. I think this was answered before about application forms and permit forms. It appears they piggyback on the Wetlands Protection Act forms, so I guess that's answered. I think this was discussed with the bylaw and it's carried over in the regulations, but should there be an election of an alternative dispute resolution procedure, such as arbitration or mediation, instead of only having litigation with regard to the town bylaw? Lastly, do you really want to penalize somebody who purchases or inherits real estate for a bylaw violation by their predecessor entitled to be required to restore the property? Wouldn't it be better to prevent the violation in the first place? Again, I don't envy your task ahead. Good luck.
Thank you. We'll go ahead and address many of those, and then we'll go to the next person.
So with regard to the map, I personally do not favor having a map that's part of the regulations and is therefore kind of the Bible on this. Wetlands are dynamic systems. They expand, they contract based on what's going around them. They are not concrete. I've done many delineations, and 5 years later, the wetland has changed because, the neighbor did something and it changed the flow of water. It happens frequently. I'm personally uncomfortable, and I can't speak for the commission, but I'm personally uncomfortable with having a concrete map that we have to rely on. That is not the way towns do this. Each site is delineated individually. The map has the DEP wetlands layer on it. That is done from aerials. It's not an exact science. It's the best they could do with the information they had. They did it statewide. Same thing with FEMA. It's done using LIDAR. It is not an actual representation of everyone's property. Many people who are shown on the FEMA maps to be in floodplain may find that in actuality they aren't if they actually had their property surveyed. I had my property surveyed, the FEMA map was wrong, and I got it changed. So I don't think it's safe to rely upon the information that we have. Alternatively, the town could spend a significant amount of money and have the wetlands delineated for the entire town, should we choose to do that. That's another option. As far as the type of filing that would be required based on the type of project, we already do that. So if it's a small project and we don't think it's going to be a big deal, if you don't think it's going to impact the wetlands, you file a request for determination of applicability. If it's a larger project, or if it's a coastal project, like seawalls, that kind of thing, you typically file a notice of intent. So that's the way that larger projects and less significant projects are kind of split. So it's not as big of a burden on the property owner.
And I'll butt in in addition to the filing for the notice, we're always open, and there are calls that come in and they say, do I even need to file a notice for this? And there are a number of projects who say, no, that doesn't even qualify enough to need the notice. And so even though it's not entrenched in there, I think that if you go out to the community and ask those that have dealt with the Conservation Committee, there are a number of things we say from the bat: no notice needed, proceed. And so that's one thing, we're open to that. And so we do a categorization. I think sometimes when you try to then entrench those categorizations into writing a regulation, it becomes more problematic than it is helpful. Please keep going.
With regard to site visits, someone from the commission always goes to a site before we make a decision. The commission as a whole may not always visit. But if it's an important project, it's a big project, we have concerns, the entire group will try to make it. Unfortunately, we don't have a conservation agent, so we do the best we can. We're volunteers. Somebody will always go. You know, larger towns, the conservation agent goes, and maybe the commission doesn't go at all. So we try to find a balance that someone always goes to look at something. And oftentimes we go and make a recommendation, you know, like Ben said, you know, sometimes it's, what should I file here? Do I need to file here? And so we go out and take a look and help people make decisions that way. You know, when you make things very specific, there's value in that because it's easier when you're reading it, but I think in actuality, it really boxes you in and gives the commission less leeway.
Hi, my name is Peter Rogel, 391 Nahant Road. I don't know any of you very well at all, but I just want to make a comment. The first time I heard you folks speak months ago about this during the Ranker this summer. So I think I have a very objective opinion because, again, I don't even remember your names other than you because I sent you an email today inadvertently. But I just want to comment, for whatever it's worth, I think you do an amazing job. You're very articulate. You come from my lens. You look like you know what you're talking about. The other gentleman there, the attorney said that just spoke that, you know, you have a thankless job. I just want you to know I appreciate that. I know a lot of people in this town do appreciate what you're doing. I think the most telling comment was months ago, someone said in that meeting this summer, it was a question regarding the incidence of you guys actually rejecting someone for a variance, and it was 0 over 5 years. And so that, I didn't check the data, but I believe you. 0 is pretty absolute. You're smart people. You know what you're doing. I just want to thank you for what you do. Thank you.
Brendan Baronic Olmsted, 2 Summer Street again. Just an additional follow-up question about the aesthetic value part. All the way at the very end, we're talking about Section B and the considerations, and mentions all these things where it does not apply. When does aesthetic value apply?
So here's the thing. Aesthetic value is in the bylaw. We're stuck with it unless we go to town meeting and take it out. So what do we do? And that's what we're trying to figure out. You know, there is no easy answer to this. We're stuck with it. And so maybe it shouldn't have originally been in there, but it is. And so now it's scoping and figuring out what to do about it. It is in the wetlands, in the model bylaw from MACC. There has never been a decision made on aesthetic values ever. I checked with them. They said a decision has never been made solely on that. I don't anticipate us using it as a consideration because for the exact reasons we're having this conversation, but it's in there, and so if you have suggestions about what we should do with it, we're open to hearing it.
Well, there are ways to have objective metrics for aesthetic values. You know, the historical societies around this Massachusetts have all set standards for when a community considers the historic look of a community as being an important part of fabric. That's something that the town could consider. There are objective ways to do that. We could pick a time period and, you know, say everyone, well, you got to do this. You know,
then we're choosing that. You know what I mean? So it's kind of an awkward.
Yeah, I mean,
it's here. What do we do?
I think what we've tried to do on aesthetic value, as I said, there's impossible. The one thing I can say about this is it's impossible. There is not a single definition I would be able to write of aesthetic value, and except for a definition that said aesthetic value doesn't exist. That would make everyone happy. Right, and so what we have to do here is, and again, our hands are tied. I mean, the thing is it's a democratic vote that put this, and aesthetic value is there. So what we've tried to do is scope it in a way that can ease the concerns by trying to take a large chunk and say, really, aesthetic value now doesn't apply to you, and so you can feel more comfortable with it. But the last part of it is just this, and I know I am also a skeptical person, so I say, you know, trust your conservation committee, and people say, I don't trust you a bit, and that's fine, but all I can say is our record. Our record has been one where we have worked with homeowners to try to get projects done very quickly, to help them fill out applications, to keep expenses down for them so they can get these projects through. What this regulation does is it brings a new group of folks into that, and we're going to work with those group of folks to try to achieve the same thing. I can't take aesthetic value out, but what we did do is try to scope it and limit its impact on our current, and we will do our best in being reasonable if we ever have to apply an aesthetic value principle to apply that reasonably.
Well, then, if we're talking about limiting impact, because there is that whole statement about to construction or extensions of a single-family home, the single-family home part, I think, needs to be defined, because you get back into whether or not, if there's apartments, if there's multiple people living in, not apartment complex, but someone who rents out their apartment, is that now two families?
Well, I guess maybe we can use the assessor's, determination. If they say it's a single-family home, it's a single-family home. I know there's a lot of illegal apartments in Hot, so we're not the police, we're not the apartment police, but maybe we can do it based on the assessor's designation.
Yep.
And if she makes that decision, it's not us, it's whatever it is. And that's what you're taxed on, and that's what it's considered. So maybe that would be a compromise on that.
Thank you.
Great.
Jeff Mussman, 15 Tri-Mountain Road. I just want to read subsection B of, section 15B of the regulations on page 15, or at least on 15 as I printed, which is the consideration of aesthetic values does not apply to any of the activities above in section 15A, or to the construction or extension of a single-family home, or to the building of a new structure separate from a single-family home on a residential lot. There are not many properties in the Hunt that are not exempted from aesthetic values. I mean, it's very simple. It doesn't affect any homeowner here in the Hunt.
As long as you clarify the application of those exemptions, because there seems to be inconsistency between the regulations, which I like much better.
And we take those, right, and we take those inconsistencies very seriously, and that's what we're going to be working with the attorneys and things on, is to try to bring clarity and deal with inconsistencies where we can, but just with the realization that regulations are by nature a little bit squishy. So we're going to take as much squish as we can get out of them, and we will certainly work on that. And we'll get that information. I agree. And we'll get that information back out to the town. Any more comments? I think we have one more person coming back to the mic.
Part two.
That's perfect.
There's a section on page 11 regarding certificate of compliance.
I'm going to interrupt you for one quick second. I recognize some people are leaving. I just want to say very quickly, we really do appreciate everybody taking the time to come out to give us their opinions on this. We welcome additional comments. We're going to do our best to address and answer questions that were asked and get those back out to the community, but we realize that everybody, it's a busy time of the year, and we appreciate you taking the time for those that have to leave. Please continue.
On page 11, under certificate of compliance, there is, in the last line, it says, if the final order of conditions contains ... and it goes on, which leads one to believe that might have the first order of conditions, an intermediate order of conditions, and a final order of conditions. And I think what you want to take away from this or understand is that makes it very uncertain, especially when it starts to include that the order of conditions, if it wasn't the original one, might call for ongoing, long-term maintenance or monitoring. And yet the very nature of this and the way it would normally happen is you apply to the Conservation Commission for an order of conditions, you get one, you have to register it at the Registry of Deeds within 30 days, and that becomes your pact or bargain with the town. Now, if that changes, and and you have to come back in and get another one, that would also have to be recorded. So perhaps instead of saying final order of conditions, latest recorded order of conditions, so that it's clear, because I think people would become nervous if starting a large construction project or renovation project on your home with an order of conditions that looks pretty trivial, and then having it changed near the end of the project to include something that might be onerous,
That's understandable. We'll get clarification as to why the language was that way.
So that certainly that question of final order conditions should be clarified. Shortly after that, in the two boxes where you have the things about the local fees, you introduce another acronym. Bordering vegetative wetland is done right. SFH is not. I thought at first it might be shellfish habitat, but it's not. It's severe hazard, a severe flooding hazard.
I think it's single-family homes.
And say again?
Single-family homes.
Single-family home?
So we'll clarify that.
Okay. There's a third. But, you know, putting those acronyms in when nobody's really sure what does that mean, probably good to put something in front of it that
Fair.
says exactly what that is.
Understood.
Someone just mentioned, I think Attorney Musman talked about the consideration of aesthetic values does not apply. This is the only place that defined term is used in the local bylaw. So is to talk about the ones that don't apply. And I understand that you have the quandary, well, it's in the bylaw. What can we do about that? Well, you have a direct liaison to the Board of Selectmen who appoint you all each year. One consideration would be to simply approach the Board of Selectmen and say, how about a simple warrant article that takes that one environmental value out of the list that's in the bylaw and make a simple one.
I'll respond to that. I'll respond to that directly, very quickly. I do think that there's some concern about aesthetic. At the same time, I do have quite respect for the democratic process that put this in place, recognizing it was close. And so the realization is the majority vote put aesthetic in. And so I do think that it's not up to us. What we're trying to do is shape a regulation that's within what was asked for through that democratic process and that is workable in our community. And so that's why we've chosen to scope aesthetic value and still, instead of trying to go against it.
Last point I'll make is under the, on page 14 and continuing on to 15, there are a list of exemptions to the regulations. And item number 6 is stacks of cordwood, if not within a wetland, that do not prevent wildlife movement. And my only question was, how big a pile of cordwood do you need in order to prevent wildlife movement? I'm unaware of any kind of wildlife presently inhabiting Nahant that would find their migration limited by an entire residential lot piled with cordwood. But I can think of a lot of different species that would make a home in a pile of cordwood.
Maybe we should outlaw cordwood then, stacking.
Say again?
Maybe we should outlaw stacking of cordwood so we don't have, pest species.
But anyway, I thought, well, that may be in other lists. I think if you went around town and tried to find who's got the biggest pile of cordwood, It'd be a pretty small one that won the contest.
Awesome. Thank you.
Third time around. All right. For under the Section 2 definitions for alterations, just more of a technical question. My particular home, I'm right on the edge of the water. I've got a hill separating me from the rest of Nahant, so the water only flows towards the ocean. My roof drains basically empty towards the ocean. During major rain events, I'm basically flushing excess amounts of fresh water into the marine environment adjacent to my house. Is that considered an alteration?
No.
Okay.
Any other questions or comments? Well, we really appreciate y'all taking the time. Well, our duty is now to take these comments. If particular points we've all been taking notes, so we can try to address these specifically, make alterations where we can. I would ask you if there are things that if you have it written down, if you can send it in so we can make sure we address your comments and questions directly and get those responses out. We'll do our best to get that turned around in a reasonable amount of time and get that back to the community. But we do appreciate you participating.
Yes. So it's the email that was on your card that was sent to your home, conservation@nahant.org. Before the regulations are adopted, we will have a public meeting, and it will be noticed in the paper, and I'm sure it'll be on Facebook, and I don't think the town will send out something to everyone again, because that's costly, but it'll be posted. Yes. Yep. We can definitely talk to them about that. So we'll have another public meeting before these are adopted, and we can put up on the Facebook on the town website an updated version of the regulations that take into account everyone's comments tonight. So thank you for everyone who provided constructive comments.
I think we have one more question.
One quick question. Someone had said that the approval of the regulations have to be approved by the Board of Selectmen. Is that correct?
No.
I thought it's just the Conservation Commission.
Just the Conservation Commission. Thank you, everyone. Do we need to vote to close the meeting?
Famous Supreme Court case in which they found that